All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, this honorable court.
Please be seated. We'll hear argument in two cases this morning. First is 2737, United Rentals North America versus Evans from Dallas County and the 5th Court of Appeals District. Justice Lehrman is not participating in that case. And second is 21509, Finley Resources against Headington Royalty from Collin County and the 5th Court of Appeals District. Justice Lehrman is expecting to participate in the decision of that case, but cannot be present this morning. The court has allotted 20 minutes for each side in the two cases, and will complete the arguments before lunch. The arguments are being webcast live this morning and will be available in the court's archives later. We're ready to hear argument in 2737.
May it please the court. Mr. Cathy will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
Thank you, Mr. Chief Justice, and may it please the court. This case was tried before the wrong jury, was submitted on the wrong theory, and yielded the wrong result. The first of those issues, the Batson issues in jury selection, and the last of those issues, the multi-million-dollar survival damages award in a case involving instantaneous death, were so obvious that non-panel members of the Dallas Court of Appeals filed two separate dissents before the parties even had the opportunity to move for in-bank reconsideration. With the court's permission, I'd like to start the conversation today with the last of those issues, the damages questions, and then discuss the two wrong turns that ultimately got us to that position. At a minimum, this court must render judgment on the plaintiff's survival damages claim. Mr. Davis was killed as a result of two massive concrete beams falling on top of his vehicle. There's no evidence that Mr. Davis survived the impact of those concrete beams or that he even perceived those beams falling. The only thing the plaintiffs have ever offered in support of their survival damages claim is conjecture and speculation, which this court has made clear is not legally sufficient evidence.
So wasn't there some testimony for the medical examiner that the skull remained intact and therefore he likely survived 10 to 15 seconds after the impact?
The medical examiner did testify, and the Court of Appeals kind of interpreted that testimony kind of in a slanted way. But when you view her testimony in context, it's quite clear that her testimony is no evidence of conscious pain and suffering. And that is because prior to the medical examiner taking the stand, United Rentals objected and said, essentially, there's no valid basis for her to opine on conscious pain and suffering. And the plaintiffs agreed with that. And they said that we will not ask the medical examiner to opine on conscious pain and suffering. So the testimony that was elicited at trial was not from the plaintiffs. That was from a co-defendant who asked the medical examiner to confirm that she could not validly opine on the existence of pain and suffering. And so what she said was...
The two factual points that I just described, skull intact, may have survived 10 to 15 seconds after impact, is that correct? I mean, that the record does contain those pieces of evidence?
He did suffer injuries to his skull, but the skull did, in large part, remain intact, and there was testimony that he would have had up to 15 seconds of oxygen in his body. That was the testimony of the medical examiner. But the ultimate conclusion from the medical examiner was that there was no way she could tell to a reasonable degree of medical certainty whether he remained conscious, was completely unconscious, or was dazed. And so there was nothing that, nothing within the medical records that she reviewed or the autopsy that would have allowed her to validly opine to a reasonable degree of medical certainty that he was conscious after the beams fell. And so I think there's really three principles, any one of three principles the court could apply in rendering its judgment, in this case, on the survival damages claim. One, the court can rely upon its precedent in things like City of Keller that says speculation is not evidence. Two, it can rely on Otis Elevator and that line of cases that's saying to the extent somebody's going to opine, offer a medical opinion, it needs to be to a reasonable degree of probability. The medical examiner in this case said she couldn't do that. And the third one is the equal inference rule. The medical examiner said there's three possible scenarios, and I can't tell you which one of them is more likely than not. And so, when you look at kind of, to sort of shift the preponderance of the evidence standard a little bit, essentially the plaintiffs had to put up 51% of the evidence that he was conscious, and the medical examiner said, I can't tell you, greater than 33% which one is more likely of those scenarios.
If we disagree and think there's some evidence of pain and suffering, how do we go about reviewing the size of the award?
And I do think that is one of the major problems with the Court of Appeals opinion. As I alluded to, I don't think the court honestly gets there, but if the court does get to the question of damages, I do think that the opinion in this case sort of underscores the unpredictability that's marred the review of non-economic damages in this case. Essentially, the Court of Appeals said, here's some testimony. Juries have essentially unlimited discretion, so we're not going to review it. And I think the major flaw that I see in the Court of Appeals opinion is that they abdicate their duty as a common law court to look at precedent and make valid comparisons between pre-existing cases and the case before them. And they really did that in two respects. First, they did it with respect to the proper method for conducting a legal sufficiency review. I think if you really compare what this court has said a legal sufficiency review entails versus what the Court of Appeals did, they didn't do that, so I don't think you get to the damages. But certainly if you do, there's an abundant amount of case law that we've cited in tab 1 of our bench book for the court, where other courts have considered the existence of a few seconds of pain and suffering, and they've essentially said that regardless of the severity, no matter how extreme the pain and suffering is, you cannot support a multi-million-dollar award off of a few seconds of pain and suffering. And so I think, the key takeaway for this court, if it gets to this excessiveness issue and the proper standard for reviewing that, is courts need to be cognizant of the fact that you need to treat like cases alike. That's one of the hallmarks of any system of justice. And the Court of Appeals essentially eschewed that and said, no two cases are comparable. But that's really
well, a jury has to start doing that. We're not here to second guess. The jury is the fact finder. We can review it for sufficiency. But I agree with you about the importance of treating like cases alike. But in order to aid the jury in doing that, shouldn't they be given some more information on what these kinds of damages are, other than just, pain? And here, physical pain and mental anguish were lumped together in a single blank, as I understand it. But there were no instructions requested, were there any instructions requested on what those mean?
The charge follows the pattern jury instructions, and so you're certainly correct that there is not a lot of information.
You didn't request the Parkway standard about nature, duration, and severity?
No, not in this case. No.
Why shouldn't we apply that standard, the nature, duration, and severity standard that we use in deciding whether there's legally sufficient evidence of the fact of damages, also to consider whether there's legally sufficient evidence of the amount of damages?
I think that is a valid point, and I do think the court should do that. I think one of the key components, obviously, in assessing the amount of damages is the duration of the pain and suffering. And so
it seems like, Parkway was about mental anguish, but it seems like nature, what's your position on whether nature, duration, and severity are also the right sort of factual comparators to look at as far as physical pain is concerned?
I do. I agree with that. I do think that those are relevant considerations that need to be taken into context. Obviously, it's kind of a holistic standard that the court has to look to, but I do think those are valid, maybe even the dominant factors that the court should consider in reviewing, or that courts should consider in reviewing the amount of damages as well.
And review would work both ways, if it was too little, if it was $1,000 in a very traumatic case.
That is correct, Your Honor, and there are Court of Appeals opinions where plaintiffs have appealed their own, verdicts in their favor, but, awarding essentially nominal amounts for $1 or $1,000, where the evidence didn't support that. So certainly, the rule would cut both ways.
On factual sufficiency, you could just say it's against the great weight and preponderance and order a new trial if it was too little.
Correct.
The Court of Appeals could. We couldn't on factual sufficiency.
Correct, and that's, as I alluded to, I don't think the court gets here, but to the extent the court addresses the standard for factual sufficiency, obviously that's a legal question this court has authority to address.
How do you rationally connect evidence of pain and suffering to a number, to an amount of money? Like, I understand you can compare to prior cases, you can say this pain and suffering was worse than that pain and suffering, but in any given case, how do you connect the evidence of pain and suffering to an amount of money in a way that is rational and non-arbitrary?
Certainly that, you've hit the nail on the head. That's a difficult task where you're trying to convert a non-monetary injury into monetary compensation. And I think, for a long time, that was the argument against allowing non-economic damages in these types of cases. But, certainly the court has crossed over that threshold and has allowed them. And so I think when you're looking at, having already kind of crossed that river and now you're in the realm of trying to rationally award economic or money damages for a non-monetary injury, I think, in other cases, and certainly in this one relevant factor is the amount of, for instance, medical expenses that were expended to alleviate the suffering. And so in this case, it's not a perfect comparison because he died instantaneously, but I do think that that's at least some indicia of, how quickly and how sudden and how short the duration of the injury was that Mr. Davis didn't even have the opportunity to seek medical attention. And so obviously if you have a large amount of medical expenditures, you're for the most part, going to have longer durations of treatment and things like that. So I do think that is one critical component that courts can look to. And obviously, in this case, there's zero, dollars that were spent to alleviate the pain and suffering. So I think that's at least, some evidence that the court can look to in trying to rationalize what is a reasonable amount to award for non-economic damages.
If we agree with you on the Batson issue, I assume we wouldn't reach any of these damages questions?
No, I think they would, so the relief that United Rental is requesting is a rendition of judgment, and I can address that next year. I think there was a wrong submission, and we owe no duty under the facts of these cases. So I think the first threshold the court has to answer is there a complete rendition in United Rental's favor? The second question is, even if a new trial is granted, either under Batson or the evidentiary and charge issues we raise, United Rentals is still requesting rendition on the survival damages claim. There's no evidence to support that claim, and that claim should not be allowed to proceed on a subsequent retrial. And so to kind of, with the last few minutes, I would like to address the wrong theory.
Before you get to that, I had one other question on the amount of damages. So the plaintiffs argue that consciousness of impending death can support an award for pre-death mental anguish. Do you disagree with that? And if not, is it a problem that this jury instruction submits both physical pain and mental anguish so that evidence of either can be sufficient to uphold the amount of damages that the jury awarded?
So my personal opinion and what we've articulated in the brief is that intermediate courts of appeals have recognized that pre-impact anguish, anticipating death is a recoverable element, but this court in Bowles quite clearly said that negligent infliction of emotional distress is not a recoverable element of damages. And I think that analysis applies because essentially the pre-impact mental anguish is an equivalent to a negligent infliction of emotional distress. There's been no impact
except
at
that
point.
there is actually a physical injury that accompanies it here.
Well, subsequent to it.
Pretty shortly subsequent.
Correct. But I don't think that ultimately should be a deciding factor for the court, because independent of whether it's a recoverable element of damages or not, there's no evidence in this case that he actually did perceive the beams falling. The evidence was that it took less than a second for the beams to fall, and the most that anybody could say was that Mr. Davis maybe perceived them. It's undisputed that he did not react to them. There's no indications from anybody else on the freeway, for instance, that he had attempted to brake or take any type of evasive action before the accident. And so I think even, again, under a legal sufficiency point, there's no evidence of pre-impact anguish or post-impact conscious pain and suffering. So for the last minute and 30 seconds, I would like to briefly address the no duty issue that we raised. This case concerns the well-defined duties of motor carriers and their drivers in an attempt to shift those duties onto shippers. Motor carriers such as large trucking and their drivers own non-delegable duties under state and federal regulations with respect to the safe loading, securing, and transportation of cargo.
But just because those are non-delegable doesn't mean other parties can't also owe the same duties, right?
Certainly they can be assumed, and so that's one of the issues in this case is you could, for instance...
Right, I'm not talking about negligent undertaking, though. A non-delegable duty is not necessarily an exclusive duty, is it?
It is not, but within this context, I do think that the duties are owed exclusively by the motor carrier.
So what about Administrative Code 21981 that says a person loading a vehicle shall comply with this chapter, and the chapter says no loads higher than 14 feet?
Well, there's two issues with that. Is one, it references back to Chapter 621 of the Texas Transportation Code, and the height requirement only applies to the drivers and its motor carriers. It doesn't apply to loaders.
But the Administrative Code applies it to loaders.
Well, it says applies Chapter 621 as applicable. And so that's the actual provisions of the Transportation Code aren't applicable. And the other thing that I would also point out is that in this context, United Rentals wasn't actually the loader of this. A loader's a clearly defined term under the transportation regulations. And in this context, the loader was actually Mr. Martinez, the driver for the motor carrier, who was essentially, spotting the positioning of the equipment on his truck.
So United's employee who drove the boom lift onto the trailer is not also a loader?
Not within the technical meaning. And certainly the only reason that United Rentals undertook that activity was because Mr. Martinez was not familiar with the operations of this specific piece of equipment. But in any other context, Mr. Martinez would have actually loaded the equipment on there. It was just because he was unfamiliar with the mechanics on this particular piece of equipment.
Any other questions? Thank you, counsel.
Thank you.
We'll hear from the respondents.
May it please the court, Mr. Alexander will present argument for the respondent.
May it please the court. I'd like to address three issues, having heard all the questions. Let me talk briefly about the pre-impact question you raised, pre-impact damages. Then I'll talk about the size of the award. You just asked about that, you too, Justice Blacklock. And then finally, conscious pain and suffering. And I can do them in different orders, but I think that would be a good way to do it. So on the pre-impact, it turns out, interestingly enough, that nationwide there is a conflict in authorities as to whether you can recover damages for the immediate appreciation of death. And so, for instance, Kansas would not allow recovery. As they pointed out, intermediate courts of appeals in Texas for years have recognized that. That appears to be in the majority view that you can recover for it. And there's a decision by this court that I'll cite, Yowell, Y-O-W-E-L-L versus Piper Aircraft, 703 Southwest 2nd, 630. And that was a decision by the Texas Supreme Court, this court in 1986. And it addressed the question of whether a plane who broke up in flight and the people plummeted to the ground, whether they could recover for that interval of time, the anguish they felt. And the answer was yes. And the phrase that this court used was, as long as it's part of the same transaction or occurrence, which of course is what we have here, as you pointed out, Justice Busby. The collision, the impact followed immediately upon it. So I think Gal answers that question.
But we don't know necessarily from the evidence whether there was consciousness,
Well,
right?
this is the point that Justice Boyd raised, and let me turn to that. So let me turn to that next. The answer is we do know. And I think that, let me tell you the authorities that you should look at with respect to that. The first one is Stodge Hill, decision by this court in 1979, 582 Southwest 2nd, 102. And that is where the court said, and let me just back up and explain. So the testimony here with respect to conscious pain and suffering came from the medical examiner. This was not a retained expert. This was someone who actually performed the autopsy.
So is there a difference between the consciousness analysis for consciousness of death and consciousness to feel pain?
Yes, yes,
Okay.
yes. In other words, there's pre-impact mental anguish.
Right,
You know, I am fearing impending death.
right.
Then there is conscious pain and suffering.
So what's the evidence on the first of those two things that says more likely than not he was conscious of impending death?
Okay,
before,
I mean, the
before
evidence.
the pain,
yeah,
before you
yeah,
get
yeah,
to
yeah.
the impact.
No,
and
the
pain.
evidence of that came from the expert witness who said that there was a interval of 0.9 of a second before, the actual collision. And if he was rendered unconscious, which I will point out to you he was not, but that was the evidence on that. It comes strictly from
But
the
I
expert.
thought the expert said maybe on that. I mean, does it have to be to a reasonable certainty on something like that?
Well, I think there has to be a reasonableness hurdle. Yes, I do. And I think in this case, I mean, clearly, if that were all we had, if we did not have conscious pain and suffering, then I don't think we could justify this award.
To be clear, not just reasonableness, but likelihood.
Reasonable likelihood, correct.
Okay.
Yes.
Not
Yes.
just reasonable to think that he might have, but that in reasonable likelihood he did.
Yes.
51%.
That's correct.
Okay.
And now, so let me turn to you want me to go to conscious pain and suffering or talk about the size of the award?
Sure.
Okay, so let's, back to that. So the Stodge Hill case by this court, again, we have the medical examiner who was not hired to do this. She did not use the magic words, reasonable medical probability, but this court said in Stodge Hill, that is not what you focus on. The other case is the one they cited, Otis Elevator versus Wood, decision by Justice Greenhill. And he says what you need to focus on is the substance of the testimony in context. And then, of course, the overlay of all that is, because this is a legal sufficiency challenge, we look at City of Keller. And so we have to look at the testimony in the light most favorable to the verdict. And I just want to read her testimony and ask the court to view it through that lens, or those lenses. This is what she says. He may or may not have been knocked unconscious, and there's no way to know for sure. I'm inserting words. Since he has no other real internal head injuries, I don't have anything anatomic, because I do anatomy, to pull me in that direction. That is, in the direction of unconsciousness. On the other hand, certainly there have been people who, in terms of anatomy, only had a subscapular hemorrhage. That's what we're talking about, a contusion. And were knocked unconscious, so that's a maybe. The only fair way that you can read that testimony, viewed through the lens, is looking at the anatomy, the hard evidence. I don't have anything, back to your point, his entire body was crushed, but his skull was not. And the injury to the head was not serious. And so her testimony is, nothing's pulling me in the direction of his being unconscious
But
anatomically.
Didn't your client have the burden to prove the consciousness necessary to experience that pain and suffering?
To the level of reasonable probability.
Right, but here, all she's saying is, well, there's some evidence of a lack of damage to the skull that
Yes.
would render him unconscious, but I don't have anything to pull me from that to consciousness. Never gets to anywhere.
No,
to
it's the other way around.
unconsciousness, To
Yeah,
unconsciousness.
it's, okay, this is the point. Anatomically, the concrete evidence, and once again, we're not talking here, this is not, cart tracks through spilled macaroni, where we don't know how long it's been on the ground. This is someone who has done 8,000 autopsies, 2,000 of them in traffic fatalities, who's testifying that anatomically, there is nothing that is pulling her in the direction of unconsciousness. She acknowledges that it's a possibility that he was rendered unconscious because, he says that's a maybe, because certain people with a minor injury, that happens to. But reading this fairly through the lens of Stodgill, Otis Elevator, and City of Keller, it compels the conclusion that she's saying, even though she's not a paid expert, in reasonable medical probability, he was conscious for 10 to 15 seconds. Which brings us now to the questions about the size of the award.
But I think Mr. Cathy said that specific testimony, that evidence, read in context, has to include that the witness then went on to say, so there are three possibilities here, and there's no way I can conclude one.
Well, then
or
I
the
think that what she's saying, again, and you viewed through the lens is, I cannot tell you with certainty which of these is true. And certainty is not the test. So she's acknowledging, as a physician who's not a professional expert, that she's acknowledging, I cannot tell you with certainty which of these was. But if you read her testimony fairly through those lenses, she's acknowledging conscious pain and suffering. So that brings us then to the size of the award. And the question was raised about Parkway, whether that could be used. I think there's a couple of things that could be used. Let's start with Parkway. I do think that Parkway is readily adaptable to conscious pain and suffering. Nature, duration, severity. And this case actually provides a solid example of how that can be done. What was the nature of the injury? This man's entire body was crushed, except for his skull. 6 of the 8 major arteries to his heart were ripped off. So the nature of his injuries are unlike any that hopefully any of us will see again. Nature. Duration, 10 to 15 seconds. Solid evidence of that. That's how much oxygen he had left in his brain. Severity, off the charts. Off the charts. The jury was entitled to conclude that if he was conscious, as they reasonably concluded, for 10 to 15 seconds, that was unimaginable pain. And $5 million.
Was there evidence about that? Because, there's this, with trauma, there's shock. And so was there evidence about the severity?
Well, nobody was with him in the vehicle. So the only evidence we have, to be clear, is the testimony of the medical examiner. That's the evidence we have. And I think that evidence, again, viewed through the lenses I've described, permits a reasonable juror, which brings me to my second point. Beyond the Parkway standard, you have 2 decisions, one from 2014, the other 2018 by this court. Waste Management versus Texas Disposal, and Anderson versus Durant, where this court says that non-pecuniary damages are measured by an amount that a reasonable person could possibly estimate as fair compensation. So that's another standard that this court has not expressly adopted for purposes of pain and suffering, but I think fits, and it dovetails nicely with your jurisprudence on factual sufficiency review. So that's another one in addition to Parkway that can be used.
Was the jury told here's the number that we think you should award, and here's why? I mean, was the jury given a reason for how you can link this number to this pain and suffering?
I don't recall specifically. I think that the answer is yes. I think that the number was larger than 5 million. I could be wrong. I mean, but part of the problem is, and we just have to recognize this. This court, I mean, they talk about how, you know, in 1886, this court rejected shocks to conscience. That's actually not true. If you look at that decision, it's Gulf versus CNSF Railroad. It's cited in their brief. What you'll see is the court wrestles with shocks to conscience and wrestles with the fact that, as you point out, how do we deal with damages? And the answer they come up with is we can't do any better than what we're doing. That is, we give it to the jury, but recognize that there are cases that are outliers. And that's where the courts intervened and corrected. In that case, they didn't. In that case, after going through the wrestling of, and this is Texas Supreme Court, wrestling with the question of what the number should be, they ultimately allowed it to stand.
And there's no intimation here that the evidence was, or the suggestion was made to award mental anguish damages for some improper purpose, like
Right.
because you should punish
Well, no,
the
and thank you.
defendant, or any, there was nothing that inflamed the jury.
There was nothing that inflamed the jury, and thank you for raising that, because if you look at the jury's answers on liability, I think that that will demonstrate to you that we're not dealing with a runaway jury. They made nuanced decisions regarding the allocation of responsibility, 50% on the truck driver, 10% on the contractor who built the bridge, 10% on the engineering company that managed the project, and 30% on United Rentals. Furthermore, they were asked for an award of punitive damages, but they did not have a unanimous verdict. And because of that, no punitive damages were awarded. So when you look at the verdict in the case, what you see is a jury that grappled with these decisions, made very nuanced decisions, and back to your point, nothing about punishment. Quite the contrary, there was no punishment that was awarded because punitive damage was not awarded.
I want to give you some time on the Batson issue, and particularly the question of whether, you know, when a lawyer gets up and says, black females are the best jurors for me, and then uses all of his strikes, or all the strikes that he uses on people who are not of that description. How do we allow that to stand? I mean, I wonder whether just that statement, as innocent as it might have felt in the context of that situation, whether that can that doesn't just pollute the proceeding and result in the kind of a record that we just should not allow to support a judgment.
Well, I think context matters. I mean, I think you hit the nail on the head with that. And the case you need to look at, and it's cited on my exhibit, Powers versus Palacios, that's the decision that they rely upon, saying that the making of that statement is per se a Batson violation. But let's look at the context in which that was made. This is what the court said. Upon inquiry from the trial court, counsel for Palacios did concede that race was a factor in his determination to exercise the peremptory challenge. The focus is on the exercise of the strike, okay? And that was the context that we were dealing with in Palacios.
Well, and your context here is that counsel is raising a Batson challenge to
Yes.
the other side.
Yes.
And saying, for whatever reason, we know this, but doesn't that demonstrate that just that both sides were using gender and race as a proxy in their jury selection? And when you have that kind of direct evidence, combined with statistical evidence, particularly here of strikes based on gender, then, then can a district court credit the race-neutral reasons that are then given to justify those strikes? So it's not a typical Batson case where there's statistical disparity, no evidence of improper motive anywhere in the record, and then you ask for race-neutral reasons, and the trial court's supposed to evaluate the credibility of those reasons. But in this case, we've got statements made about using improper discriminatory reasons as proxies for potential biases in the case.
Well,
What do we do with that?
what we have here is that clearly, and you look at the pattern of their strikes, and you look at the statement made, both sides are aware. I mean, both sides have jury consultants. Let's clear that up. They had two, we had one.
Well,
Clearly,
why are jury consultants telling people lawyers to pick jurors based on race and gender? Should
That
they
would be,
quit that?
that's a Batson violation. That is a Batson violation. If the strikes are made based upon race, that's a Batson violation. And that's why, in this case, the trial judge did what this court has told it to do, and that went through for 78 pages. And that's not counting the time she spent studying it, looking at each side's explanations for their strikes.
Well, a good lawyer is probably going to be able to come up with another explanation. So what do we do with that?
Well, what you do with that is what the court said in Batson and this court said in Davis. We trust the trial court to make those credibility determinations.
Even when there's an express admission that one of the things that they're looking at is what their jury consultant told them to look at, which is race and gender.
Well, let's look at that. So in the Batson case, we had an African-American defendant being represented by an attorney who says they are striking because of race. That lawyer is saying they are striking people favorable to my client. This case in Davis, the plaintiff is an African-American. The strikes being made they are trying to strike people who are favorable to my client. So if you ask those lawyers in those cases, are you saying that the black juror is going to be more favorable to your client? What's the answer going to be? Yes. So unless you just want to do away with Batson and say that anytime somebody who is transparently saying, I'm trying to protect my client, then you can't get there. So when you look at, and we don't have time in 46 seconds, but when you look through each of the examinations of the strike made by this trial judge, where an explanation was being provided as to this is why I was doing it, it's very clear that there was no abuse of discretion, and that's the standard.
What if the other side had got up and said, we know that white men are the best jurors.
Said what?
We know that white men are the best jurors, and that's why, Your Honor, that's why that explains our behavior and their behavior. I feel like we wouldn't be here arguing about this. I think everybody would. That would shock the conscience, right? To use the term from the damages discussion, and I wonder why this doesn't equally shock the conscience.
Well, I think once again, you have to do it in terms of the context in which it was made. This is not Powers versus Palacios. He is not talking, we're not at the strike stage. He is saying exactly what a lawyer would be saying, representing the client in Batson and Davis. I am trying to protect something from strikes. And let me just take a few moments to just talk about.
Well, I take your point that you could make that argument in connection with the other side's strikes.
Yes.
But does that immunize you from an examination of the strikes you've made?
No. And in this case, there were 5 challenges, and the trial judge went through each one by one, and listened to the evidence, did exactly what this court said to do, which is to judge the credibility for those explanations, and concluded that these were not race motivated. And look here. Let me just spend one moment because I know the next argument has been put off. So let me. I'm over the red light. Up to you, Chief. 1 minute. So, when you look at the strikes that were made by the plaintiffs in this case. Justice Evans says plaintiffs used 100% of their strikes on non-black men. And so that is pregnant with notions that the plaintiffs were making nuanced decisions about gender and race. But when you look at the chart, and the idea being that they were leaving black men alone, how many black men are there here? There's none. So, and the fact that they used only 5 of the 6 strikes is important. I mean, the intimation, the inference on this record is had they had more strikes, they would have struck more males. They had more strikes. They didn't strike more males. So again, back to the main question, the fact that this lawyer was transparent in explaining why it was that they were exercising their strikes in the way they were doing, which is what you're required to do at stage 3 of Batson. That's the burden. He's saying this to carry the burden. That cannot be flipped around and go, aha, you've committed the Batson violation, we get a new trial.
We can't get rid of Batson, but if we got rid of peremptory strikes, we wouldn't have this problem either, would we?
True. But that's not.
As opposed to having decisions from this court instructing people on how to carefully describe.
Yeah, but that would be,
statements.
yeah, I mean, and that would be a discussion for another day, whether, we should get rid of peremptory strikes. But I mean, the answer to your question straight up is true.
Any other questions? Thank you, Mr. Alexander. Jesse, I believe you have 5 minutes.
Thank you. I'd like to begin my rebuttal by addressing the damages issue, which consumed the majority of the questioning for the respondent. And the first is to address the question with regard to whether the testimony of the medical examiner was speculative. We cited that testimony in our brief, but for the court's reference, it's 16, volume 16, reporter's record, page 42. And the medical examiner is asked explicitly whether one or other of the case, whether, as between the 3 options, it's pure speculation even to you as a medical doctor and a medical scientist. And the answer is there is nothing to distinguish those. I mean, the medical examiner admitted it would be pure speculation for her to testify that he was conscious. And that is the gist of the testimony that is in the record. And that's the ultimate conclusion that was left by the medical examiner. And with respect to how the jury arrived at its award, it was an improper argument to answer Justice Bland's question. The jury was told by plaintiff's counsel to award $10 million and divide it up however you see fit. There was no attempt to link the $5 million award in this case to the duration of any conscious pain and suffering. I mean, presumably because there was none. And so this is kind of a situation where you have, in Bentley, where this court admonished, made clear that juries cannot just fill in the blank with anything based off of attorney argument, which is not evidence. And that's precisely what occurred in this case. The jury came back with a $9.7 million total award. We're here challenging the $5 million survival damages award. But the jury did exactly.
What if counsel had not suggested a global number, but just said to the jury, use your best judgment in determining the amount? Would there be anything wrong with that?
I don't know that that would be improper per se in terms of reversible error, but certainly I think that would be fodder for a sufficiency challenge and would be relevant to a court's analysis. And I think when you look at tab 1 of our bench book, I went back and readjusted all of the numbers for inflation through today. And the average award for seconds of conscious pain and suffering is $66,000 unadjusted for inflation and $120,000. So the award in this case is 41 times larger than the inflation-adjusted average in cases. And there's just no explanation for that kind of outlier.
If we were to look at other cases, do you have a position on how we should do that? The Fifth Circuit uses the maximum recovery rule. Other courts have done it differently. What's your position on that? If we do that, what's the right way to do it?
My position would be that the court needs to look at affirmed awards where there was a sufficiency challenge. And the reason I say that is because I don't think you can just take jury verdicts. In a perfect world, liability facts would not influence damages, but it's quite clear that we don't live in a perfect world and that, inflammatory liability facts do affect juries' damages numbers. And so I think if you look at just sheer verdicts or results where a court of appeals affirmed but it was subsequently overturned for, on liability or something else, I don't think those are valid comparisons because clearly you had this improper influence on the jury's verdicts in those cases. And so I do think to the extent the court's going to look at anything, it should be affirmed verdicts in other cases where there was a sufficiency challenge. And with the last minute, I would like to briefly touch upon something that wasn't addressed and that I do think the court should not overlook, and that is our request for rendition. In this case, United Rentals not only, it fulfilled its duties as the shipper in this case. It not only provided the equipment that was requested by Mr. Martinez, but it provided a bill of lading that laid out all of the specifications for that equipment, including its height and its size. And so that bill of lading confirmed what was obvious to everybody, was that Mr. Martinez was tasked with delivering a boom lift to Irving. And the fact that Mr. Martinez signed the bill of lading, I think, is consequential. That confirms that he had the right piece of equipment. The plaintiffs in this case are continually asserting that he didn't have the right piece of equipment based off of some pre-existing bid documentation. But the case law we have cited has been quite clear that the bill of lading superseded all of those prior documents.
Let's say
so on that-
if we disagree with you on this duty question. I understood you to say earlier that you have a separate, you consider your no evidence challenge on the non-economic damages to be a separate rendition point.
I do.
As to that
Correct,
claim.
Your Honor. I do think even if we get a new trial, Your Honor, I think that claim should be excluded from the new trial, and rendition would be appropriate on that.
Any other questions? Thank you, counsel. The case is submitted.
Thank you, Your Honor.
And the court will take a brief recess. Please be seated. We'll hear argument in 21-509, Finley Resources against Headington Royalty.
May it please the court, Mr. Clinton and Mr. Keltner will present argument for the petitioners. Petitioners have reserved 5 minutes for rebuttal. Mr. Clinton will open with the first 15 minutes, and Mr. Keltner will present the rebuttal.
May it please the court. The issue in this case is whether plaintiff's discharge and release of Petro Canyon and its predecessor of any liability of any kind or character, known or unknown, in any way related to a single square mile of land in Loving County, Texas, discharged Petro Canyon's predecessor in interest, title, operations, rights, liability, and responsibilities as to that very same single square mile of land in Loving County, Texas. Applying this court's ordinary rules of contract construction and the ordinary meaning of the words of the parties, the answer to that question is self-evidently yes. But the Court of Appeals reached the opposite result only by becoming the first court in the history of Texas to hold that releases and discharges of liability are disfavored forfeitures under Texas law, and therefore should be construed against their application. Petitioners therefore respectfully request that this court reverse the judgment of the Court of Appeals and render judgment that plaintiff take nothing.
There's a long line of cases that say that in this state, unless a party is named in a release, he is not released. And we've glossed that to say named or specifically identified, so if there's not a proper name. But we've held pretty closely to that, starting with McMillan and then Angus Chemical versus IMC Fertilizer and Duncan versus Cessna, where the release said corporations, and the court said that's not specific enough to release Duncan's action against Cessna. So why would we depart from that rule in this case?
Well, first of all, I would take issue a little bit with the premise, because I do think that the court has said it's either by name or with sufficient particularity. So the court
specifically identified.
Yes, with some specific particularity. And so there are a host of cases where a category of parties with a relationship to the settling party was determined to be sufficient to meet that sufficient particularity test. This court has never held that you could not identify a category of settling parties like employees and shareholders. The court has simply said there must be some sufficient particularity so that you could establish a connection between the settling party and the third party that is named in the agreement.
But
and
what
here,
if the category is itself ambiguous as to its scope?
that's certainly a possibility. It's not here. I mean, there's no ambiguity as to what predecessors mean.
Well, it seems like it could mean either corporate predecessors or predecessors in title or both. Why isn't that an ambiguity?
Sure. As this court has said many times, simply because two parties are arguing about the definition of something doesn't make it ambiguous. What makes it ambiguous is if we simply don't know what the word means. The word predecessor has the same meaning. Or
if we know that it has several possible meanings and we don't know which one is intended.
Well, the word predecessor in ordinary meaning only has one meaning, and that is something that comes before in either party, place, or position, in role, place, or position, sorry. So it's something that comes before. That's what the word predecessor means. If there is that line of cases, as Your Honor wrote one of them, that said that there has to be something more than that to be predecessors. Of course, that was Great American, and this court ultimately overruled Great American versus Primo, and said that, no, we're going to look to the context of the agreement itself. We're not going to have.
And if we do that here, then why don't we look to agents and representatives, and that's not a predecessor in title?
We absolutely can look to, and we agree that we should look to the entirety of the clause to determine its meaning. And agents and the word predecessor is surrounded by agents and representatives. Both of those are outside of course, any formal corporate context. By definition, an agent and a representative is not within the formal corporate context.
But it has an in personam relationship to the entity that's granting the release. or that's being released. And here, if you just compare it to Duncan, the word was corporations. And that too has a meaning that we're capable of understanding and employing, but it didn't mean every corporation. And because there was no other specific identifier, the court concluded that it was not, that the party was not released.
Well, in that case, it was any corporation whomsoever responsible. And the court said, look, this essentially unlimited category, any corporation whomsoever responsible, that there's no connection to the release. Here, we don't have any corporation whomsoever responsible. We have the predecessors of the parties. There is only one predecessor of Petro Canyon.
As to this transaction.
As to the
lease.
As to the set of facts that are governed here, there is only one
But
predecessor.
presumably, there were lots of predecessors with respect to other transactions.
That is true.
But you don't think that's included in predecessors?
Well, I think that we can look to the entirety of the clause to determine its meaning. And the clause is very clearly limited to the subject matter, which is the specific square mile of land. So I'm not sure I would concede necessarily that it's limited to those, but that informs its meaning.
What if there had been 5 prior leases on this tract and maybe a couple of them only included a couple of acres of this section? Would the people holding those leases be predecessors under your view?
Well, I think
maybe
that
the royalty is different, and maybe it's carved up in other ways.
If I would say 2 things. First of all, the word predecessor is a broad word, and it means those who come before. But even if you wanted to say there must be some specific connection.
Is it the same interest in that situation? It seems like the interest would be different if the lease is different, because you have to be what you're being a predecessor to is the leasehold interest, right? Not the minerals.
Not necessarily, because the clause here is not tied to the leasehold interest that was transferred.
But that's the only interest that your client had, that any of the parties here had, right? They're not mineral interest owners.
Well, they were interested in, I mean, they're interested in as operators, they're interested as lessees.
Okay, so why isn't that the interest that we look at?
Well, the clause itself says that the clause applies to anything having in any way related to this subject matter as stated, but in the subject matter as stated is the square mile of land. It would be one thing if the parties had said,
right, but you're the one that wants to read in the words in interest. And so don't we have to define what the interest is? It's not the tract.
We're not reading anything into the clause, Your Honor. We're saying that the word predecessor means what it means, and it has an ordinary meaning. And going back to the question of the Houston, that line of cases from Houston and Enchanted, and the line of cases that this court, at least in Primo, reversed, each of those cases said we look to rights and responsibilities, that perhaps we can define, even if predecessors is something more narrow than its ordinary meaning, we look to its rights and responsibilities. Here, the plaintiff's claim is to the rights and responsibilities contained within the deed records that preceded the leasehold going to Finley here. And those very same rights and responsibilities were transferred to Petro Canyon. So the very rights and responsibilities upon which plaintiff is suing in this case are rights and responsibilities that Petro Canyon took on. So they are the direct predecessor with respect to the very basis of the claims at issue here.
So, but if it had only been for half the tract, you would say no.
I'm not sure I would, Your Honor, because again,
Or 2 acres. I mean, when do the rights and responsibilities become different? Or if it's pooled with something else?
What I'm saying, Your Honor, is under any definition of the word predecessor, we meet it. Finley meets it. If you give it its ordinary meaning, we meet it. We are the predecessor. We are the ones who operated previously. We are the ones who owned it previously. We are the ones who had the rights and responsibilities previously.
So it doesn't depend on whether the lease that was quitclaimed was in fact still valid at that time?
Not at all, not at all, because, for a lot of reasons. One is that, again, we're predecessor regardless of that. But was specifically with respect to
But
that.
it would be a break in the chain of title if it had lapsed for lack of production.
It would be a break in the chain of title, but it would not make us a predecessor. We're still the predecessor whether that title has broken at some point, because we were still the predecessor operator, we're still the predecessor in interest, regardless of whether that lease had terminated.
Even if the interest is different?
Again, that's a hypothetical. I believe it probably would be if you read the plain language of this agreement, which is that it goes to relation in any way to the Loving County tract. That is how these parties chose to define the interest that they were absolving each other of liability on. It went to the Loving County tract. So the court, of course, is well familiar with the general rules of construction, which is that we give effect to the party's intent as expressed in the ordinary meaning of the terms they use. There is an ordinary meaning of the word predecessor. It means that who came before. And again, under any definition of that, even under the restricted definition of that Houston Court of Appeals line of cases.
Well, no, this is from the Texas Supreme Court, that the identification needs to be with such descriptive particularity that his identity or his connection with the tortious act is not in doubt.
And we believe that has absolutely been met here. There is only one predecessor. There is only one potential predecessor in this entire factual scenario.
How do we know that if we can't look at parole evidence?
Well, an objective fact and circumstance is not parole evidence that a court couldn't consider. I mean, how would you even determine how to apply the clause if you couldn't figure out who the parties were? I mean, knowing who the predecessors are is not parole evidence. The court has always said you could look to an objective fact and circumstance. Of course, it doesn't alter the meaning, but it informs the meaning. Here, there is only one, and that's one of the things that the Court of Appeals dissent said.
It's only ever been leased one time before?
No, there's only one predecessor of Petro Canyon with respect to this entire relationship. They're the only.
I thought what you said is if there was a lease on this square mile before, it's a predecessor.
Well, yes, that's true.
So how many predecessors were there?
If it has to be a predecessor in title only, there were a few before this. That's true. But they would, even under that reasoning, Finley would still satisfy it because they were the immediate predecessor.
So if the dispute here was whether they were a shareholder or an affiliate or a director or an officer or representative, your position would be courts would always have to look at some kind of extrinsic evidence to determine whether the release covered that party, but doing so would not violate the parole evidence rule.
I think that's correct. I don't see how you could ever apply any contract if you couldn't determine what the facts were. So here you would simply be applying the provision in determining, in looking to whom the predecessor is in that instance.
So there's also a release of representatives, and this is fanciful, but you might come in and argue, well, that's a release of my representative in Congress, which is textually, sure, right? But that's a special case of representative that, based on the context, we can tell was not intended here.
I agree
and I wonder
with that.
whether predecessor in title is sort of a term of art, a special case of a particular usage of the word predecessor that is not often what is meant by the word when it appears alone.
I would agree with your hypothetical that there are certain interests or parties or entities that might be so attenuated from the facts of the case that it certainly probably wasn't in the contemplation of the parties that that's what they intended. Here we have
but it's not their attenuation from the facts of the case, it's their attenuation from the normal usage of the word. So you talk about somebody's representatives, unless you have special reason to think they're talking about their member of Congress, you would never think that that's what they're talking about. And I wonder whether predecessor in title is a little bit like that, sort of a very special case of the use of the word predecessor.
I don't think it is, Your Honor. Again, the word predecessor, the ordinary meaning of the word predecessor is someone who comes before. That's the ordinary meaning. And court after court across America has applied that ordinary meaning. And in court, of course, this court did very similarly in the Primo versus Great American Insurance, where this court was looking to the words successor. And the court said that successor was the person, that was an entity who succeeded, and it didn't have to be a corporate type capacity. And the reason that the court did is it said we look to the ordinary meaning, and the ordinary meaning of succeeds was someone who came after. And we also look to the very purpose and intent of the provision at issue. Here, the purpose and intent of the provision at issue is clearly a broad discharge of liability. I don't think that anyone could read this provision and think that the parties intended this to have a narrow scope, that it was going to be limited to something less than the ordinary meaning of the word. It says discharges Petro Canyon, its affiliates, officers, directors, shareholders, employees, agents, predecessors for any liabilities, claims, demands, causes of action of whatever character and kind, strict liability, negligence, breach of contract, all related, unknown or known, fixed or contingent, related in any way to the Loving County
But
tribe.
does that broad generality help us here when because there's no reference to a specific suit, a specific claim, specific other entities that would allow us to sort of give more meaning to predecessors because it is just so broad.
There is a reference. The reference is to the Loving County Tract. This is a single square mile of land that the entire transaction, or this entire provision was based on. That is the subject matter of the clause. That is what ties.
So if an insurance agent was supposed to write insurance regarding the operations on the tract and didn't do that for some reason, is that claim released by the word agent?
I'm not sure. I mean, again, I think you could get to the point where perhaps arguably it was so attenuated that that's not what they meant. They probably meant agents with respect to this particular transaction. So plausibly. But here, again...
Or you could get to the point where you can't say they probably meant one thing or the other, you're just not sure. So it's ambiguous. Assume we disagree with you and conclude that this is just ambiguous. We don't know if the parties meant predecessor in interest or corporate predecessor or both. Assume that's where we go. Is it your position that it then becomes a fact issue on ambiguity, or do you concede that, as Justice Bland has described our precedent, you lose because it's not clear enough under Duncan?
It would be our position that you would remand for a new trial. I don't think that there is... I do not read the court's 70s and 80s precedent as adopting mechanical rules that say that we're going to turn away releases anytime we're not sure what they say. And I think that this court's post Cessna jurisprudence and Keck and Kessler, they all really bring back some of that expansive language.
Didn't we reaffirm the principle in 1997 in a one-page opinion? Angus Chemical versus IMC Fertilizer. In this state, unless a party is named and released, he is not released.
I think that I'm not sure. I'd have to go look at that case. In McMillan, which was where that language came from, McMillan was actually talking about Alaska law. So that phrase from McMillan came from Alaska law. It was saying Alaska says it has to be named, and if you're not named, but that's not what we're going to hold. What we hold is that it has to be of some sufficient particularity so that it shows that there's a connection to the cause of action. Here there is an absolute connection to the cause of action, which is there is only one predecessor directly related to this cause of action. The parties, we knew about it. They were talking about it. There is evidence in the record that they in fact were fully informed by their own lawyer that Petro Canyon's predecessor here was Finley. Their own lawyer told them that. They, in fact, in internal correspondence were saying, we don't know why they took on.
So it sounds like a remand, if it's ambiguous, would be just fine for you.
In a way, that's absolutely right, Your Honor, because we only think the case gets worse for them if you actually look at the facts. But we don't think the court has to look at the facts because we think that it is not ambiguous.
This is unique language, right? This is not typical language that you see in contract documents in oil and gas lease transactions.
I've not seen a lot of discharges of liability within assignments.
Any other questions? Thank you, counsel. We'll hear from the respondent.
May it please the court, Mr. Hastings will present argument for the respondents.
May it please the court. The petitioners are here asking the court to hold as a matter of law that Headington released Finley for a $54.5 million claim through a document that does not mention Finley, does not mention this claim that's allegedly being released. It doesn't even mention that there was a dispute between Headington and Finley. Headington
Counsel says it was discussed at the closing. Is that true?
Your Honor, what was discussed, the fact that this release covering Finley, no, that was not discussed. Your Honor, that would be getting into parole evidence, but whether or not this release was covering Finley was not discussed. If it had been discussed, Headington's answer would have been no. They were not releasing a $50 million claim. This court should be reading the acreage swap agreement and the release in accordance with well-settled principles. And Justice Bland, you're absolutely right about reading Texas law. The law is clear, and it starts with Duncan, Brady, and Kessler. The first sentence of Kessler is a great place to start, and the petitioners keep citing Kessler. The first sentence of Kessler says what the rule is. A party needs to be named or described with particularity so that their identity is not in doubt. If they wanted to try to name and negotiate for Finley, they needed to do more than just a reference to the word predecessor. It does not get
in your view, predecessor does that because it specifically identifies a category of released parties. So, for example, insurers is often used in releases. And under your construction, could somebody come in and say, well, you by saying insurers, you may have released the primary carrier, but not the excess carrier because you didn't describe the various kinds of insurers that are out there that might be covering the claim.
Your Honor, I want to respond first with the language of the agreement itself, but also the case law. There is no reading of this contract that gets to predecessor as the petitioners are arguing. As far as the contract goes, it says Petro Canyon's predecessor. The predecessor of Petro Canyon. It doesn't say the predecessor to some part of Petro Canyon somewhere. It says the predecessor of Petro Canyon.
Or its affiliates.
Or its affiliates, yes, Your Honor. But it's still the predecessor of the whole entity, not some random part of it. But second, the case law. At the times the parties are negotiating this agreement, the court,
You're saying it says predecessor of Petro Canyon, not predecessor of the leasehold interest.
That's correct, Your Honor. And I will come back to the leasehold interest because even if the court were to go broader than that, it still doesn't help Finley. But I will come back to that. As far as the case law goes, at the time the parties are negotiating this release, you have cases like Falstaff and Enchanted Estates, which say the classic plain meaning of predecessor in this type of context refers to the entity. Those were before the agreement, but since the agreement, this court in Broadway National Bank says the same thing. The predecessor-successor relationship, classic meaning, is focused on the relationship of those entities. If the parties wanted it to mean something else, they should have included different language.
I did think it was a little interesting, this one doesn't say successor. I mean, a lot of times when you're just like listing all these corporate relations, you say predecessor or successor. Here it only says predecessor, which seems to me in context to support the petitioner's position that the parties knew here who they were talking about, the one and only predecessor in interest.
Well, Your Honor, I will agree with you that it's often in context with both words being used. But as the court can look at the case law, for example, the Great American case that was cited several times, they use the word successor. They don't use the word predecessor. It uses successor, but that case, by the way, also includes assigns, so it's a very different fact pattern. So the different wording could have been used. But as far as who's the predecessor, this agreement itself tells us If you were going to look at predecessor and title, the petitioners want to run to the end of the agreement to say this is about Loving County tract. If you read the provision itself, it's referring to claims on the Loving County tract, not the parties. But if the court were to agree that we should be looking at the Loving County tract, it's still, the agreement itself tells us where Petro Canyon got its title and its rights. So if that's what the parties meant, this agreement on page 1 and page 2 tells us where Petro Canyon got its rights. It did not get rights from Finley, from a quitclaim. A quitclaim of nothing is still nothing. And so we're in a situation where the plain meaning of predecessor should lead to the conclusion that Finley have a corporate affiliation and is not the predecessor. But even a more expansive reading should lead to the conclusion, if the court were to say predecessor and interest, even a more expansive reading doesn't get the petitioners there because Finley was not the predecessor in interest. There is no reading of this clause that helps the petitioners and gets them to the point that they want to get to try to get Finley a release here.
Do you mean because of the lapse?
Your Honor, two reasons. One is plain meaning, just like Broadway National Bank, it's limited to the corporate relationship. If the court were to go beyond that and start buying into the petitioner's argument that you should go broader, then the issue of lapse comes up.
Okay.
So it's two parts.
So you're saying even if we were to read the word predecessor to include predecessors in interest or title,
yes,
that Finley here is not a predecessor in interest or title because it lapsed before, the lease lapsed, the interest lapsed before Petro took over?
Absolutely, Your Honor. And I need to talk about surrounding circumstances because this is an objective fact. All the parties acknowledge that surrounding circumstances can be considered by a court when reading an agreement in context. It's only the objective facts that may be considered. And I take issue with something Petro Canyon says on page 22 of its reply. It says there's no evidence that the Arrington lease terminated. Well, that's just wrong. On page 2 and page 35 of our brief, we've cited an extensive amount of evidence to support the lapse of the Arrington lease, including the sworn testimony from Petro Canyon, page 467 of the record, paragraphs 4 and 5, where Petro Canyon's own witness told the district court they determined the lease lapsed, and Petro Canyon's view was the lease lapsed. So that was an objective fact. It's the baseline under which this entire agreement was being negotiated. So when Petro Canyon now says there's no evidence of a lapse, they have completely changed positions and are saying the exact opposite of what they told the district court in this case.
Are you saying that if predecessors means predecessors in interest or title, there can only be one?
Correct.
Why is that the case?
Because the contract tells us who the predecessor in title is.
It's predecessors.
Well, there's only one. It tells us exactly where.
Are all of these people our predecessors?
I mean, that's, Your Honor, that's part of the problem. If you read the contract the way petitioners do, you start getting into anyone in the world. If you read the word predecessor in title according to the acreage swap agreement, it tells you exactly where Petro Canyon got its rights and who Petro Canyon's predecessor was. It says it on pages 1 and 2 of the acreage swap agreement and identifies it as work. There is no connection between work and Finley.
Is there any agreement between the parties that requires indemnity for claims?
Your Honor, to put that in context, after this acreage, at the time this acreage swap agreement was signed, Headington had no knowledge of any such agreement. There's no evidence that Headington had any knowledge of such an agreement at the time this was signed.
But your client did.
Headington did not.
Headington did not.
Headington did not.
But could they have?
What we learned about after the fact, so the acreage swap agreement signed at the beginning of October, it's put into place. At the end of October, they filed a quitclaim of record with the indemnity language that's at issue. So that's a fact that the petitioners knew, did not disclose. There's no evidence. Even if you go to all the parole evidence that they cite in this case, there's no one that says there's no evidence to show that the actual terms of that agreement were signed or the indemnity was signed. Headington's evidence is Mr. Mahand said unequivocally, they did not tell me this point. And so if they had disclosed what they were doing, we could be in a different situation. but they didn't. The petitioners, if they wanted a release, as the court knows, releases are defenses to claims. Usually in court, the party asserting the release has the burden to prove that they have a release. The same should be the case for a party who wants to get a release. They need to make sure they get a document that signs and covers what they want. If they wanted to cover Finley, they should have put it in the document. They did not. This court should follow settled principles and not change Texas law. If you think about this, these broad readings of predecessor, imagine what that does to settlements. One point we will agree with petitioners on is Texas does have a public policy favoring settlements. That's a policy favoring parties coming together to try to resolve their disputes. If we're going to start changing Texas law and allowing very broad categories to be used when reading releases, how in the world are parties going to be able to negotiate settlements? They're asking for something that's a detriment to the very policy they claim to be concerned about.
When Finley assigned its rights to Petro's affiliate, Petro in that agreement agreed to assume all liabilities that Finley might have incurred with regard to the Loving Tract, correct?
Your Honor, it appears that they did.
Okay, so in order for Petro to fulfill that contractual obligation, did it have to get a release of Finley in its subsequent agreement with Headington?
Not necessarily, Your Honor. We don't know. That's an issue that ultimately has to get sorted out in the trial court. But what they can't do is negotiate their private deal where they're not disclosing what the terms are between the parties. And if you look at the timing, watch the timing closely in the record.
I understand that, but I'm just trying to really kind of narrow this down. It just seems to me that if Petro agreed to assume all liabilities to protect Finley when it accepted the assignment of the interest, the tract, then later it enters into this agreement with Headington, and Headington may have claims against Finley, wouldn't Petro have had to have gotten a release or other protection of Finley or else be in breach of its prior agreement?
Well, Your Honor, I don't believe that they would have had to have gotten a release. And if they're in a breach of their prior agreement, that's an issue between those parties.
Well, I know,
it doesn't make it a release that Headington agreed. They can't agree among themselves that Headington's going to give up a $50 million claim. It'd be a nice trick if they could, but that's not Texas law.
Well, we say specifically identify the party being released, but we're very general with respect to claims, all claims of whatever kind, and the claim doesn't necessarily have to be recited or disclosed. And so, if we have that approach with respect to claims, should we take the broader view of categories and say, okay, a specific identification of a category is enough?
No, Your Honor. On the claims, as I understand Texas law, it requires a clear articulation of what's being done. It's certainly true that that parties can get to a broad release of claims, but they have to be very clear to do so. It should be the same for parties. If you want to get broad releases of parties, you have to be clear, not just taking a word like predecessor that prior case law has said refers to a corporate context.
Do you agree that the standard that would govern releases of claims and the standard that would govern releases of parties is the same?
They're at least extremely similar, Your Honor. They should be narrowly construed, as this court has said, and it needs to be clear language. So I guess, yes, I guess it would be the same. It needs to be very clear. And the policy of making people write their agreements clearly, that furthers the ultimate goal of settlement. I mean, what better to effectuate the intent of the parties and the policy of people coming together to resolve their disagreements, to at least mention what their disagreements were that are being resolved.
But when it comes to claims, we've said that our principle that we're describing about these releases doesn't require that the parties anticipate and identify each potential cause of action relating to the release's subject matter, which seems different from what you're describing in terms of this degree of identification of the specific granular kind of claim that would be released.
And Your Honor, that's why I was hesitating a little bit, because I haven't worked through every nuance of how the claim versus the party issue works. When it comes to claims, the parties, if they want everything possible covered, they need all that language. We want to cover all claims, known, unknown, foreseen, unforeseen, all of that stuff. Parties.
Which by definition means you can't identify by name every claim that's being released.
And you're
Right.
being very clear about it.
Yeah.
That's the problem. When it comes to parties, you're not. If parties wanted to negotiate a release that said, we're going to release Petro Canyon and any person affiliated with them in any way that we could either foresee or not foresee, we might be in a different case. But they didn't do that. They said Petro Canyon's predecessor. And so the plain meaning of that should be looked at as the predecessor of Petro Canyon.
If we conclude it's ambiguous, I know you say it's not, and that you both say it's not ambiguous, but you have different proposed meanings. But if we concluded both your proposed meanings were reasonable and therefore it's ambiguous, is it your position that it therefore has to go to a jury or fact finder to determine the party's intent, or do Duncan and Brady and our precedent kick in and say, well, then therefore there's no release because it doesn't identify them by name or with sufficient particularity?
And Your Honor, it's the latter. And ultimately, for the first time ever in this case, in this court, the petitioners have suggested this agreement as an alternative. I know it's their alternative argument, might be ambiguous. If the court were to reach that question, and we've cited some cases, I believe, from Iowa and Wyoming, some other state Supreme Courts have recognized, well, if you get to ambiguity, you've already lost, because it's not meeting the standard. It's not meeting the clear identification standard.
So it's like the insurance context where if it's ambiguous, the tie goes to the insured and there's not a trial on ambiguity? Is that your position?
Yes, Your Honor, and there are circumstances. I mean, think about it. This court dealt with one in the the Endeavor versus Energen case, special limitations in oil and gas leases. When the court concluded this is ambiguous, ultimately because of the way Texas law is. Texas law, just like releases, has a requirement that if you want a special limitation, it must be stated clearly. And because it was ambiguous, that necessarily meant it was not stated clearly. We're in a very similar situation to that.
If the language had said all predecessors of any kind, would that be sufficient to capture your client?
Your Honor, I do not believe so, because predecessors had the case law describing predecessors in the classic meaning. And so I don't believe that would be enough, but that's also not our case. And so as far as...
You would say that that's any kind of any kind of predecessor in the corporate context is still
Yes.
what that would mean?
Yes, Your Honor.
Or alternatively, any kind of predecessor to this particular title which had lapsed?
If they wanted to say that, they could have said that, but they did not say title. And so there's two problems.
Right,
One,
but I thought your second argument was even if it was broad enough to include title, that they weren't a predecessor to this title because the lease lapsed.
Your Honor, you beat me to it. I was about to say there's 2 points there. One is they didn't say title, but second, if they had, there's a break in the chain of title. And so there's a problem there. And so if you read this release the way petitioners are, we don't know where it would stop. We would not know who has been released under this agreement. I mean, you think about it, there was a good hypothetical asked, what happened if only half of the interest was transferred to Petro Canyon? Would that make you a predecessor? I would ask a different one. What would happen if Findlay transferred an interest in Dallas to Petro Canyon instead of Loving County? Are they now a predecessor under this agreement? If you follow the petitioner's arguments to the logical conclusion, there's no end. If there's no end to terms like this, that would be a huge deterrent to parties coming together to voluntarily resolve their disputes and settle. They're undermining their own principle.
The last line does limit it to the Loving County tract.
No, Your Honor.
Related in any way to the Loving County tract.
No, Your Honor, because that's referring to the claims. That is the release of what the claims are. And if you look at it, it's not saying we're releasing the agents at the Loving County tract or we're releasing the employees on the Loving County tract. It's not the predecessors on the Loving County tract. We're releasing the predecessors, agents, representatives on one side of who's being released. And then you look
Of
at the
Petro
claim.
Canyon.
Exactly, Your Honor. And then you look at the other
But
part.
that does limit the universe, because there's only a limited universe of people who can bring the claim associated with the Loving County tract.
It does in theory, but you also have a situation where if there's a transfer of rights, let's say if Findlay had never conveyed the Loving County, the Arrington lease to Petro Canyon, but it conveyed something off in Dallas, hundreds of miles away, they could argue that they're a predecessor. They still have that predecessor relationship, even though Findlay had been on the same track. I mean, you can work through the hypotheticals. There's no end to the analysis that the petitioners are asking for, which is perhaps the biggest deterrent you could have to trying to get settlements done, and it would be expressly contrary to this court's precedent. This court should stick with precedent, keep people's expectations settled when they're negotiating contracts, and not
When you
open
did
this up.
the release, there was an exclusion for pre-existing plugging and restoration
Yes.
liability with respect to the wells. But why would that be necessary if predecessors didn't include predecessors in title?
Because, Your Honor, for reasons, and if you look in the record, there's no explanation for this. There is parole evidence where Headington expressed confusion as to why this happened. But while the parties were negotiating the release, there had been no disclosure of the quitclaim and the indemnity terms, but there was the filing of a P4 with the Railroad Commission. And all of a sudden, Double Eagle's taking over as operator of Findlay's wells. Because of that, on the P4 form, if you read the instructions, that is the designated document as to who's responsible for plug and abandonment. It resulted in a very quick, Headington's not releasing anyone for that liability. Petro Canyon took on that liability, that's their problem. That's why that came up, is because of the P4 being filed in the public record. That was the only disclosure.
Any other questions? Thank you, Mr. Hastings.
Thank you, Your Honors.
Mr. Keller, you have 5 minutes.
Thank you, Your Honor. May it please the court. Let me address two things. First, about the categorical releases, Justice Bland. You had the most questions on those, Justice Busby. You joined them. And the issue there was, in Duncan, we said you've got to identify the party or a category of parties with particularity. Let's talk about that for a minute, because I think certainly Duncan says that. And certainly in 1997, there were several decisions. One of them was Kessler, though. And Kessler addressed the very point and referred back to Duncan and said, in Duncan, we have qualified Duncan already. It is sufficient to describe with particularity the released party's identity or the connection with the event. That has given rise to a number of cases at the courts of appeals. Let me just give you a couple of them because they're important. And the reason I'm doing this is, if you take away categorical releases, which is really what Headington has asked, you're going to radically change the landscape in Texas. In Schomburg versus TRW, the release of the unnamed component part manufacturers released a seatbelt manufacturer. In Quiroz versus Jump Street, a release of people, unnamed entities that were released, and actually what the court said was all individuals and entities involved in the operation of Jump Street. Unnamed, completely unnamed. Way to figure those out? I guess yes. Go look at Jump Street and figure that out. Tom versus Rebels Honky Tonk, that was one of the spinning bulls in the honky tonk, and the question was, is released owners? Well, the court found that those were unnamed, and you had to go look, but there were several owners, and there was even an owner of an owner. They were released. Anderson versus Medtronics, Randy Crane, Southern District of Texas, relying on Duncan and the changes in Duncan that came later, and says, look, truth of the matter is unnamed manufacturers of an infusion set were included in a release that simply identified suppliers of Medtronic. That's what the law in Texas is. You're not going to find another case that carves down on that. We've looked. Now, the truth of the matter is Duncan went far. and Justice Spears was addressing a lot of things. Most of Duncan has been overruled. Brady came soon thereafter, written by Justice Hightower in 91. It follows Duncan, but it was a narrow release. How can I tell you that it was narrow and made a difference? Because the court said this in two cases. First, the Kate Mahan and Kate case, and then later Kessler pointed out Brady, we carved back Brady because Brady involved a very specific release related to one transaction only. And what had happened in that case is they were trying to get a release of different liability. And they said these releases that are broad, and look what we have here, known and unknown.
So what is the standard what do you say the standard is under our current precedent?
Under current precedent, I think the standard is this, that it is names, no doubt about that, names specifically. If you don't, you list with reasonable description, so reasonable particularity is how the courts say it. And if you name a category, the category is sufficient. And you have to go look and see what the category is. Let me, Justice Young, answer your question about the difference between broadness of claims and broadness of who is actually released. Think about it. In Kate Mahan and Kate, what the whole settlement agreement about was release of unpaid attorney's fees. What the court determined, this court determined, was what was released was a malpractice claim for things that came later or during that same period. Well, no, actually later. And that has been consistent with what we have seen.
That's helpful in terms of the general standard, but it doesn't seem to help on the application here as much, because we still have to figure out what predecessors means in the particular context of this agreement and whether that category is sufficiently clear to include predecessors and title.
Let me take on two things. I've got just a few minutes left. First off, we disagree totally with the idea that they didn't know about the predecessor relationship where there's a break in title. The evidence is completely different than that. I wrote it down to be able to give you the record sites. Because they are important. Give me a second.
If everybody knows about the relationship,
right,
and in particular, just assume that everybody even knows that you have some indemnity relationship to the predecessor, whose burden is it to make sure that if that entity is going to be included, it is included? Who should have come forward and said, and by this we mean Finley?
Well, they take the position it's solely ours. And the truth of the matter is, when you're drafting a document, it's both parties. This court's even taken the position that is, if you look to hang and this is in Piranha Partners, that if you look to hang the person who drafted the document, you can only do that if there is an ambiguity. And there, in the break of title thing, one last thing, and I know my time's up. It's a red herring. It's red herring in this regard. Remember what happens. Finley, first off, what happens, Petro Canyon thinks, not certain, thinks that there's a cessation of production. They top lease. They discuss it with Finley. There's a possibility of litigation. What happens is Finley agrees to assign to avoid the kind of lawsuit you took on in Red Deer and that kind of thing. That was the reason for this, and they knew about it. And I would say Headington not only knew about it, knew that there was an assumption of liabilities on behalf of Petro Canyon, and knew that Petro Canyon thought those were released.
Any other questions? Thank you, Mr. Keltner. The case is submitted. That concludes the arguments, and the case is set for this morning, and the marshal will adjourn the court.
All right. Oyez. 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 The Honorable, the Supreme Court of Texas now stands adjourned.